13 years spent in a coma. Supreme Court decision and a turning point. Now, an emotional final goodbye. First ever to die with dignity. Here's everything that's happening and happens next.
Welcome back. I'm Uday Pratap Singh. You're joining us on NewsX. Tonight we're talking of a story about life, about suffering, about love, and about a question that has troubled humanity for centuries. When medicine can no longer heal, what does dignity mean? That's going to be our focus on NewsX Explained today. A 22-second video that has since surfaced on social media captures those final moments of Harish Rana. In the clip, his mother sits beside him, her face marked by years of exhaustion and grief. A member of the Brahma Kumaris places a tilak on his forehead and gently strokes his head. Her words are soft, almost maternal. Forgive everyone, apologize to everyone, it's time to go now, it's okay.
सबको माफ करते हुए और सबसे माफी मांगते हुए उठ जाओ, ठीक है?
Those words mark the beginning of the end of a 13-year struggle, because Harish Rana is now at AIIMS Delhi, where doctors have begun the process of gradually withdrawing life support. It is a step taken under the supervision of medical boards and under the authority of a historic ruling by the Supreme Court of India. For the first time in the country's history, a court has allowed passive euthanasia for a specific individual, granting Harish Rana what the Constitution now recognizes as the right to die with dignity. But to understand how we arrived at this moment, we have to go back to August 2013. Harish Rana was then a young student studying at Punjab University in Chandigarh. Friends describe him as energetic, sporty and passionate about football. Like many young students living away from home, he was staying in a paying guest accommodation near the campus. One night, tragedy struck. Harish fell from the 4th floor of the building. The accident caused catastrophic brain injuries. Doctors rushed him to hospital, but the damage was severe. The trauma left him with irreversible brain damage and quadriplegia. From that day forward, Harish never regained consciousness. Doctors placed him on life support. A tracheostomy tube helped him breathe. A feeding tube supplied nutrition and hydration. Machines and medical intervention kept his body alive, but medically his condition never improved. For 13 long years, Harish remained in what doctors call a persistent vegetative state, a condition where the body survives, but consciousness never returns. Patients in such states cannot communicate, cannot respond meaningfully, and often have no realistic chance of recovery. Through all these years, Harish's parents never left his side. The Supreme Court itself later acknowledged their extraordinary devotion. In his judgment, the bench noted that the family had stood as unyielding pillars of support, caring for their son with unwavering dedication despite the emotional and financial strain. But after more than a decade with no signs of recovery, the family reached a painful conclusion. They believed their son was no longer living, he was merely being kept alive. And so they approached the courts with a heartbreaking plea: allow him to die with dignity. The legal journey that followed was complex. India does not permit active euthanasia, which involves deliberately administering substances to cause death. That remains illegal. However, the law does recognize passive euthanasia under certain circumstances. Passive euthanasia refers to the withdrawal or withholding of life-sustaining treatment when a patient has no hope of recovery and continuing treatment only prolongs suffering. But even that process involves strict safeguards. In Harish Rana's case, one major legal question emerged: would removing feeding tubes used to provide nutrition and hydration count as passive euthanasia, beg your pardon, or would it amount to actively causing death? Well, the case ultimately reached the Supreme Court. On March 11, 2026, a bench of Justices Pardiwala and Vishwanathan delivered a landmark verdict. The court permitted the withdrawal of Harish Rana's life-sustaining treatment, including medically assisted nutrition and hydration, but the judges emphasized that the process must be carried out in a humane manner. The ruling relied heavily on a crucial precedent from 2018, the Common Cause versus Union of India judgment. In that case, a 5-judge bench of the Supreme Court recognized that the right to die with dignity is part of the fundamental right to life under Article 21 of the Constitution. The court also introduced the concept of a living will, a document through which a person can state in advance that they do not want life-sustaining treatment if they become terminally ill or fall into a permanent vegetative state. However, the law also provided a detailed procedure for situations where no such directive exists. According to advocate Rashmi Nandakumar, who represented the Rana family, the process involves two levels of medical review. First, a primary medical board evaluates the patient's condition. If it concludes that withdrawal of treatment is inappropriate, the hospital must then form a secondary medical board. The second board conducts its own examination, reviews the medical records and determines whether it agrees with the first board's assessment. If both boards concur, the hospital informs the judicial magistrate and the patient's family before proceeding. In Harish Rana's case, those medical evaluations confirm what doctors had long believed: his condition was irreversible. The court therefore allowed the withdrawal of treatment, enabling the family's request. But the judgment went beyond legal reasoning. It was deeply emotional. In a moving passage, the Supreme Court reflected on the fragility of life and the cruelty of suffering that cannot even be expressed. For the past 13 years, the bench wrote the applicant has lived a life defined by pain and suffering, stripped of the ability to even give voice to his anguish. The judges praised the Rana family's love and endurance, noting that the greatest tragedy in life is not death but abandonment. Despite the catastrophic tragedy that struck the applicant, the court observed his family never left his side. The judgment also carried a powerful philosophical reflection. This decision, the court said, does not neatly fit within logic and reason alone. It sits in a space between love, loss, medicine and mercy. Perhaps the most important line of the ruling was this: this decision is not about choosing death but about not artificially prolonging life. The distinction is crucial because the court was not permitting death, it was permitting nature to take its course. When medicine could no longer restore life, the Harish Rana case also stands in the shadow of another tragic story that shaped India's euthanasia debate. In 1973, a young nurse named Aruna Shanbhog was brutally sexually assaulted at a Mumbai hospital where she worked. The attack left her with severe brain damage. For more than 4 decades, she remained in a vegetative state. In 2009, journalist Pinky Virani filed a plea seeking permission to end Shanbhog's life. In 2011, the Supreme Court rejected that request, but it made history by recognizing the concept of passive euthanasia for the first time. The court, however, ruled that such decisions would require approval from the relevant High Court under strict safeguards. Aruna Shanbhog continued to live under medical care until she died of pneumonia in 2015, 42 years after the assault. That case laid the foundation for later legal developments. Then came the landmark Common Cause judgment of 2018, which formally recognized the right to die with dignity. In 2023, the Supreme Court simplified the procedure, making it easier for families and doctors to follow the process without excessive legal hurdles. The Rana case is therefore part of a long legal revolution, one that reflects changing attitudes towards end-of-life care, but beyond the legal framework lies a deeply human story. Harish's father, Ashok Rana, spoke after the judgment. Listen.
जो हम करने जा रहे वो हुआ है, वो हम चाहते थे। ऐसे ही हमें न्यायाधीश टकरे जिन्होंने वो जजमेंट दी। 3 साल हो गए लड़ाई लड़ते हुए। कौन माता पिता अपना चाहता है कि अपने बेटे को ऐसे करे, परंतु हम चाहते कि जनहित में ऐसे पता नहीं हरीश जैसे कितने लोग पड़े हैं, उनका भी कल्याण हो। तो इसलिए ये मामला जो है चलता गया हाई कोर्ट से सुप्रीम कोर्ट में दोबारा अपील करी और आज हमें सफलता मिली है।
The Supreme Court itself acknowledged that India still lacks comprehensive legislation on end-of-life care. In its 338-page judgment, the bench noted that courts have repeatedly had to fill a legislative vacuum. What does dignity mean at the end of life? Where should society draw the line between preserving life and prolonging suffering? And how should medical systems support families facing such decisions? Across the world, different countries have adopted different approaches. Some nations, including Belgium, Canada, the Netherlands, Spain and New Zealand, have legal frameworks that permit euthanasia or assisted dying under strict conditions. Others continue to prohibit it entirely. India has chosen a middle path, allowing passive euthanasia under strict safeguards while prohibiting active euthanasia. For now, Harish Rana's journey is entering its final chapter. At AIIMS Delhi, doctors are carefully withdrawing medical support that sustained his body for more than a decade. The process is gradual and medically supervised. And for his family, it's not the end of a fight, it is the end of a vigil that lasted 13 years.
13 years spent in a coma. Supreme Court decision and a turning point. Now, an emotional final goodbye. First ever to die with dignity. Here's everything that's happening and happens next.